broadcast. Okay. So a very good evening to all of you, and the second series of the AOCN Web Academy lectures for pediatric neurologists. Today we have a slightly off the track topic. We are not going to talk about core neurology today, but to learn about something interesting and something very relevant, and especially in these digital times. We have a very one of the young rising stars in pediatric neurology from Kolkata, and our chairperson today here is Dr. Rashmi Kumar. Ma'am is ex-professor and head Department of Pediatrics, KGMU. She's also been a past president of the AOCN. She has done extensive work on viral encephalitis and epidemiology and neurodevelopmental disorders. She's a winner of several awards. She's one very senior and looked up to person in pediatric neurology. And she's a much loved, I would say, teacher and physician, excellent clinician. And now she is, she hasn't retired still, she's still working. She's working as a community technical expert for community at the community center. So I request ma'am to please introduce our young star Diptanshu and chair the session. Thank you, ma'am.
Thank you, Suhasini. Now, the speaker for today is Dr. Diptanshu Das. He is consultant pediatric neurologist at Medica Super Speciality Hospital and Institute of Child Health, Kolkata. He is a member of the Education and Publication Council of the Indian International League Against Epilepsy. He is also editor-in-chief of the International League Against Epilepsy Wikipedia project, a board member of the Wikimedia Medicine, and member of the working group of Open Access India. So he's just the right person to be talking to us about our rights to our work. And his talk will also cover ethics, research, and academics. So we look forward to a very interesting talk. Over to you, Diptanshu.
Thank you, ma'am. I'll start my screen sharing. Is it visible?
Yes, sir.
Okay. So the topic for today would be rights to our work and what we pediatric neurologists need to know about it. Now, first, the slides are not moving. Just a minute. Okay, I'll start with a special acknowledgement to coronavirus, because without this pandemic, probably we had not felt the urge to arrange for such a beautiful web series, webinar series. I think everybody is benefiting from it. In today's session, brief about intellectual property and rights and the context in India, what is fair use and right to cite. I'll cover confidentiality issues and how to maintain a balance about how much to reserve for ourselves, how much to share. It will also cover research and publication ethics and ways to make collaborative contributions. It will also cover open data and fair data. And lastly, the considerations in the digital age of today. So, intellectual property. Firstly, what's the context for doctors? First, what is intellectual property? It refers to creations of the mind, such as inventions, literary and artistic works, designs and symbols, names and images used in commerce. This is the definition given by World Intellectual Property Organization. It basically provides legal protection to innovators and tries to promote research and innovation, and tries to strike a balance between the interest of the innovators and the wider public. So basically, it tries to protect creativity, which is arts, protecting innovation, which is science, and protecting commercial interest, which is the commerce behind. Now, medical science is basically a combination of all three. And with respect to doctors, whatever we do counts as intellectual property. It's not something physical. So, what we are doing needs to be protected. And unless we understand how to do it, it's a trouble. So the other context is many of the doctors are academicians and or research oriented. So in case of research, publication comes in, and in case of publication, a proper understanding of the rights of the author is important. Similarly, when academician shares his or her work with the greater audience, it is very important to understand uh, how much of it uh, they should restrict and how much they can freely share. Now, intellectual property rights comes in many headings. It could be patents, which is basically exclusive right for an invention. Copyright refers to work of works like books, music, painting, sculpture, films, uh, anything textual, programs, databases, technical drawings, advertisements, maps, etc. Uh, Trademarks, which are basically the mark of the company, various designs. It could be design of any equipment. It could be design of some architectural designs and things like that. It could be trade secret, that is the things that a company can capitalize on. And there are geographical indicators as well. We'll come briefly to each of them. So, what are just okay? So patents are exclusive rights granted for an invention. Here we can see the patent diagram of a stethoscope, which was filed in 1882. Here is the patent drawing that was submitted in 1899 for hypodermic needles. This is for the BP cuff. And this is a more complex instrumentation. And right now, for example, in case of ventilators, a lot of patents are involved in making of a single equipment such as a ventilator. So these exclusive rights for an invention cover a product or process, a new way of doing something, and the term is for 20 years renewable. And these are with respect to the country where they are being registered, but can extend to other regions as well. The registration for a patent can be done through IP India nic.in. I'm not going to the details because we'll have to rush. Copyrights, on the other hand, are the rights that creators have over their own work. Uh, uh, in the in one side of the page, we can see the copyright page of a particular publication where it says that copyright 2000 by Sage Publications. Now, here we have to note one thing. This book is written by certain authors, but the copyright is held by Sage Publications. So probably a copyright transfer has occurred. We'll come to that soon. So in India, copyright lasts for lifetime of the author plus 70 years. And you need not do a registration, but you can if you wish. Coming to trademarks, these are some trademarks. These are a few Indian trademarks. Coming to design, this is the building of Infosys, Pune. The building design can come under IP protection. This is actually a virtual image, but had it been a real one, I think this design could be uh, uh, protected by intellectual property rights as well. This is the design of a Tetra Pak. We all know what a Tetra Pak is, and this is also under IP protection. The bottles that we see, these also come under it. Domain names, various internet sites that we see, these are also under IP protection. Various plant varieties, the various subtypes of each of the species that are there. These comes under plant varieties. And GI tags, this is basically when a particular area has a particular uh, item that has unique properties attached to the particular region. For example, I'm from West Bengal. In West Bengal, Rasgulla is very famous. Uh, West Bengal Rasgulla or Bangla Rasgulla is distinguished from Orissa Rasgulla, which is also there. Uh, this image from Times of India shows the various various GI tags that are in use. Coming to trade secrets, it applies to new inventions and also various formula like that of Coke. Coming to patents, uh, they are applicable for a term of 20 years and are renewable. Uh, this could be design patent, which could be applicable for 15 years. Uh, Trademarks are potentially indefinite. I've already mentioned copyrights are life plus 70 years, and trade secrets, once again, potentially indefinite. So what cannot be protected by copyright or IP protection? Mere discovery of a scientific principle, mere admixture or rearrangement of known devices, these cannot be protected. The idea itself cannot be protected. When a particular process for treatment is used on human beings, that process cannot be patented. Methods of agriculture or horticulture, those can't. Frivolous invention, just minor or against natural laws. For example, perpetual motion machines. These cannot be copyrighted or patented. Methods of playing a game, choreographic works, fashion, uh, these cannot be protected. And names, titles, short phrases, expressions, these cannot be. So there's a term called fair use. When we are using it for research, education, etc., certain copyright granted materials can be made use of. But there's a catch. The amount is restricted. For example, up to 10% of the work, or even less than that, if we are making use of that much, that can count under fair use. Or in case of database, once again, up to 10% of the fields that can be used if we are using it under fair use. will come upon plagiarism, which is basically where you do not hold the rights. So, in case of copyright or IP protection, it's ultimately your work and you hold the rights. But in case of plagiarism, you are essentially making use of somebody else's work without uh, direct acknowledgement, and you are just taking it from there. This is unacceptable. So, this is basically a research misconduct, and fabrication, falsification also count as misconduct along with plagiarism. So it could also be accidental or unintentional plagiarism. For example, suppose I read something from somewhere and I just paraphrase it. I just do close paraphrasing or just minimal paraphrasing. So ultimately, that could count as plagiarism. If I do not use those, it could count as plagiarism. And quoting excessively, as I've mentioned that there's a limit on how much we can use. If we use more than that, it can count as plagiarism. There are various plagiarism check softwares available. Not going into that. Uh, Various incidents have happened, and that has also involved pretty high profile people. For example, in 2013, German education minister Annette Schavan, she had to resign because of her plagiarism in her thesis work. Uh, Similar newses keep coming. For example, this is another from where Indian Express had to withdraw an article. Mm, The even in case of scientists, such things are not new. The problem further can occur when you yourself are not doing the plagiarism, but if you choose your co-authors inappropriately, where ultimately your co-authors do plagiarism and you are a part of it, things can turn messy. And this is the case where the original author ultimately committed suicide. Uh, Based on plagiarism, ultimately there are a lot of scientific retractions that are occurring when eventually we find that a journal article is based on fabricated data, falsification is involved, or there is plagiarism involved. So this is the data about the retraction. We'll come to another concept now, which is about copy left. So, what is copyright? Where you, the copyright holder, have ultimately, basically says that ultimately you are sharing the work and it's some rights reserved. So one thing is when the work is in public domain, when anybody can use it. For example, when a copyright expires, it goes into public domain. The work of Rabindranath Tagore now comes under, it actually is a repository of a lot of work that has were public domain. Uh, Sorry. In case of Creative Commons license, it's basically a agreement between the author and user, where the user author is making explicit what he or she is allowing and what he or she is not. So suppose in this digital age, work that I do is ultimately going to be shared. And for example, whether or not I mention, many people can take screenshots. Now, this is basically a derivative work of this presentation. So, if I can strike a agreement with the users that for my work, this is what I'm allowing and this is what I'm not allowing, uh, things can become a lot easier. This can be done by using a Creative Commons license on the work. So under this license, work can be copied, distributed, edited, remixed, and developed, and the entire thing occurs within the limits of copyright law. Here are various types of Creative Commons licenses. Uh, the signs that are used are given on the left. The first thing, attribution, means uh, ultimately you can use the work, but you are obliged to attribute it to the original author. The essay or share alike clause makes it obligatory to share under a compatible or same license. If you attach NC, that is non-commercial, you are saying that people can use it only on a non-commercial basis. But the distinction between non-commercial is a gray area. For example, suppose a profit-making agency makes, goes into a charity and uses your work. So is this non-commercial or commercial? On the other hand, suppose a non-profit uses some work of use, some work of use, where ultimately they are generating funds. So in every case, this distinction is not very definite. For example, for educators, they do charge tuition fees from their students. So if a particular work is used even for teaching your students, are you really using it commercially or non-commercially? So really, this NC is a gray zone, and I myself do not like it. There are many people who do, but I've clearly mentioned the uh, limitations. ND is non-derivative, where you are allowing the people to share the work as is, but you're not allowing derivative work. So in those combinations, these are the licenses that are possible. So there are various forms that can be there. The most free is CCBY, Creative Commons BY is by attribution. Uh, Next comes CCBY SA, non-derivative, non-commercial, where we use non-commercial with um share alike, and CCBY NCND, where it is both non-commercial and non-derivatives. So here is the spectrum where uh, first you have CC0, where you don't even need to attribute it. You can just use it freely. There are sites like Pixabay, which have images that are available under CC0. There are libraries like the US, I'm forgetting the name, uh, where the copyright expired and the government generated work, those are listed in public domain. So those things can come under CC0. And thereafter, I have already explained the spectrum. Uh, who uses such licenses? These are a few organizations who use Creative Commons license. This is an article from Epilepsy Open, which uses open access. And if you can have a look, you can see that this particular work is under NC, non-commercial. You can see the dollar sign that is striked off, but otherwise you can use it freely. There are others which use only CCBY. So what are the benefits? It provides global recognition to your work. Since your work is available, people can access it more easily, and it can be used internationally. Uh, the community can benefit thanks to its open access, and it's easy to find, use, or understand. You can use search.creativecommons.org to find which work uses Creative Commons. Here's an example where this image, you can use it freely, but you need to attribute it to the original author. This is how you can attribute it. Now about going open. I'll come to the case of Jonas Salk. I think you all have heard of him. Uh, he's the person behind oral polio vaccine. Today, the world is being liberated of polio, and very soon will think that it never existed. How is this happening? Uh, this is because Jonas Salk did not patent his work. He left his. It's estimated that he forsaked about billions of dollars, which otherwise he could have earned. But ultimately, it's the world population who would have lost that money. He did not take that, and ultimately, by virtue of that, the world is being liberated of polio virus. Uh, Coming to the internet is not a library, and the things that we can find on the net by searching, it's only limited to less than 10%. Why? We'll just come in the next slide. And furthermore, whatever you find online, that does not need to be authentic. Uh, Google is not a certification authority for authenticity. And while searching, might not get the most relevant results in the top. So this is how the web actually looks. If we use search engines like Google or Wikipedia to find, it's just a handful of information. But what exactly can we not find on Google? For example, uh, if you think of your email, it is ultimately in somewhere locked up by a password. So not freely available for everybody to access. Medical records, legal documents, scientific reports, subscription information, academic information, multilingual databases. Multilingual means if it is not in English, by search in English, I'll not get it. Financial records, government resources, organization specific repositories, and competitor websites. These uh, comprise a bulk where ultimately these do not show up because these are restricted access. And so web crawlers cannot find this information. And there's another thing called dark web, which is Tor encrypted sites, which can ultimately be browsed through specific uh, routes, like there's a Tor browser. I'm not going into the details, but it may contain various illegal information and stuff that is otherwise not allowed. So to search deep resources, mind out, I'm talking about the deep web here. There are various search mechanisms and meta engines that can be used. Uh, uh, Deep resources comprise of dynamic web pages. For example, if I search something, it's a dynamic page, and it's generated right there. It's not something that's stored. So this page cannot be found through web search. Unlinked content. Suppose I have a page, but there are no pages linking to it. This page cannot be found. Private web, which is protected by registration and login, as I mentioned. Limited access web. For example, there are sites which require you to click on certain captcha to prove that you are a human. Those cannot be accessed by machine or web crawlers. Scripted pages like uh, pages produced by JavaScript, Flash, Ajax, those cannot be searched. For example, when you click on a search box, suggestions come in that are you trying to search for this? These are usually done by Ajax. Non-HTML contents. For example, there's an image, but if there's no tagging done, images or videos, these are otherwise not going to show up. There are, as I was mentioning, there are various specific search engines that can find it. Uh, Here are a few, and that also includes PubMed. PubMed can search the metadata of articles and can give you articles that are paywalled. Maybe it will give you just the abstract, but at least you can find it. There are various open access repositories and open access journal directory. We'll come to those. So what exactly is open access? Where your work is freely available for download, copying, distribution, print, search, or linking to full text. Uh, the It is free to be crawled, and that is why Google can find open access articles. And if your article is open access, it's more easy to find. Uh, This data can also be processed by machine, artificial intelligence, and artificial data processing, artificial reality. Those are uh, buzzwords of today, and these are these things can access open access journals. DOAJ, or Directory of Open Access Journals, lists the uh, journal journals by various parameters, and you can find them there. For example, this is a search query where I have mentioned that find neurology uh, journals where there are no APC or article processing charges, and these are I have not given the exclusive list. These are the ones. So that way we can find articles that meet our requirements. Here's one. When we click on it, for example, we can go to pediatric neurology briefs, and it shows that there's no article processing charge. So I can submit an article for open access publication directly, and I do not need to pay anything. This is another journal, Wiki Journal of Medicine. It's basically on the Wikimedia space. Wikimedia is the publisher of Wikipedia. Uh, we have a scientific academic journal there, which is open access, peer reviewed, and it is free both for authors as well as uh, the readers. So both the authors and readers can access use it for free. This is about Wiki Journal of Medicine. Uh, Coming to collaborative contribution, ultimately, this is something Newton has said, if I have seen further than others, it is by standing upon the shoulders of giants. So, if you want to do good work, it's always better to benefit from the work of others. And if you make your work available, ultimately it can be used more effectively. Wikipedia is an example where ultimately people are collaboratively contributing, and such a vast encyclopedia has been built up. It's entirely open access. Anybody can access the Wikipedia articles. Those are Wikipedia uses a CC BY SA licensing, which is Creative Commons uh, license. Uh, by SA, you are obliged to uh, use the same uh, licensing as it uses. There are various journals which now make it obligatory for you to store your data, the research data, uh, openly. This is because ultimately other people can make use of your data. They can base upon your work the data which maybe you have collected for 10 years, and ultimately they can analyze the data to find various things from there. If we remember the Dutch famine study, uh, the data was well preserved, it was properly documented, everything was systematically documented, and based on that, we now know a lot about how infant nutrition and its paucity can expose to various adult ailments like cardiovascular diseases and diabetes. So since that data was available, we can analyze it. But if that data is paywalled or restricted, ultimately people cannot do anything from that. There's another concept where you can have fair data. Fair means findable, accessible, interoperable, and reusable data. Here, you're not giving away the data. You're storing it on your own servers. It could be the hospital servers. Ultimately, if you have privacy concerns that you do not wish to give out the data, but ultimately you keep the data findable, so people can know that there's something that you have done and where to find that. It should be accessible. For example, fair data is accessible by bots, so AI resources can make use of it. A typical example can be, suppose a hospital has a MRI repository. Ultimately, it's not giving out the MRIs, but if you have any specific query, it's allowing you to search the database, access the database. It might put some limiters, or it could make it freely accessible. But that is an example of fair data. There are various open access repositories. I'm not going into the details, uh, but there you can store the data, and uh, it can be collaboratively used. Uh, this is about the fair data that I was mentioning. Uh, Nowadays, a lot of things have been eased. For example, if you people want to work together, you can just open up a Google Doc and share the link. A number of people can work together, and this is an example where some person has done something, somebody else has done something else, and the entire thing happens live. So you can track the changes and do the work real fast, where multiple people can collaborate very fast. The ILA Wikipedia project, this is basically a effort where ILA sees value in making the information accessible for all. So the ILA journals, the data that is there, the information, the purpose of the project is to make this data widely available through Wikipedia. Wikipedia is a very highly used resource, and a lot of medical people use Wikipedia. Even the lay people use Wikipedia for information. So uh, it's there are a lot of organizations that are finding value in enhancing the information there. Uh, if you are interested, definitely you can ping me, and uh, will be happy to have you as a part of the project. There are others like Cochrane collaboration, where Cochrane is working on uh, improving the uh, presence of Cochrane studies, the uh, uh, Cochrane reviews, uh, and incorporating them into Wikipedia. So basically, Wikipedia has a wide reach because it's open access, and there are organizations that are utilizing it. Now let me come to entirely different domain, which is about patient rights. We need to understand the work that we do has two parts: the work that we do and the work that is based on that of patients. So when we use patient material in various forms, it is obligatory that you obtain the consent of the patient.
Hello,
Make use of
Diptanshu.
it. So the
Okay, I thought you'd gone off there. You come back. Okay.
Yeah, Diptanshu, we don't see you or hear you. Is there a
okay,
problem?
uh, can you see it now?
Yeah, yeah, we can see it
Yes.
now.
Okay.
Okay. Privacy basically respects the patient's body, whereas confidentiality respects the patient's information. So information there is confidential, and there's a trust factor involved when the patient shares health information with the uh, health sorry the patient shares the information with the health professionals. So when we use the data for educational purpose or otherwise, we need to make sure we obtain consent. And when we obtain consent, basically there are various technicalities involved. For example, you need to catalog the work. You are obtaining uh, consent for what exactly? Is it for educational use? Is it for publication? So things need to be specified, and there needs to be a particular format for that. And when interesting patient comes to you in the OPD, you need to do it right away, because ultimately otherwise you might not get a scope. Now here another problem comes in, because when you're doing it, the patient might find it fishy and might not give you consent. Even if it happens, you'll have to respect that. So what is confidential? All identifiable patient information, whether written, computerized, visually, or audio recorded, or simply held in the memory of professionals, is subject to duty of confidentiality. And the patient data that is there ultimately counts as uh, patient data is as per the MCI, it's the property of a patient. So when a patient demands it, you are obliged to share it. Uh, Medical secret is defined as any medical information that comes to the knowledge of practitioners as a result of their work, whether directly obtained or from a patient or otherwise. Conditions where you might disclose medical secrets is if it is required by the judiciary, if it is a publicly uh, informable, public notifiable information, or if uh, there are various threats involved, where it could be either self-harm or where the patient consciously and truly admits of committing a crime, and of course by approval or consent of the patient or kin. And there's a patient consent format available. If you just search ICMR patient consent, you'll get it. So that is it in a nutshell. Thank you.
I think you can stop screen sharing now, Diptanshu. Yeah.
Thank you,
Yeah.
Diptanshu. Uh,
So
so I think it was a very interesting topic, very huge topic. Diptanshu started with the types of intellectual property and the rules governing them. Then he went on to, so many things that we hear about, um, plagiarism being very important. Then going on to open access, Creative Commons, and finally coming on to patient rights and confidentiality. So all these things are extremely important. The first part of the talk was mostly for people who are going into publications and patenting. And the last part was basically about the patient rights and how we need to protect the patient. All these things are so very important in the internet age. And this topic is a very fluid topic. It's changing every day. And every day the concepts about all these things, the copyright, etc., these things are also changing, and it's actually a very very huge topic, and we've just touched upon it. In fact, I think there could be one or two more sessions on going into the nitty gritty and the details, especially for people who are into publication. This would be very, very, I think all anybody who's publishing should be exposed to this kind of talk in a more detailed way, actually. And so I think it's been very interesting, quite an eye opener, and in the internet age, this is really very much needed. So that's what I had to say about it. Now, another thing is, just one or two things like plagiarism. How does one catch plagiarism? There are software available where even, a phrase of about 6 words that would, which is taken exactly as it is from another source, would be caught. So, so one has to be careful that you don't copy verbatim from anywhere. And but I didn't understand a little bit about oversighting, what you meant by oversighting. And another thing I would say is that you mentioned public domain, but can you explain to the the audience what exactly means public domain? Okay.
Uh, for example, when I mentioned about Rabindranath Tagore's work, the author has already 70 years has elapsed after his death. So now he or Bharati is no longer the holder of copyright. So now who holds the copyright? The answer is nobody. So here it's this work is now everybody's property. So this is what public domain is. There are governments who make their own work available in public domain. So the US, for example, has a policy of making its certain work available under public domain. For example, the NASA, uh, the images that NASA produces, those are available in public domain. And suppose I do something, I produce some work, and I say that I do not need any credits for this, use it freely. That is available in public domain.
Yes, but Diptanshu, would this information be given somewhere that, whether it is in public domain or not? If you just go
Yes,
to the web
the
and
answer
start,
is yes, because if you search the web, even on Google Advanced Search, you can specify that whether the information is free and public domain information, and you'll get images which are public domain, other materials that are public domain.
okay, so it should be part of the search criteria.
Right.
Okay, okay. What about newspapers and all? I mean, if you get information from a newspaper, so would that be called public domain?
Uh, in case of no, in case of newspaper, there are two things involved. The work that is there, the text that is contained, that is one thing, and the physical copy. When you purchase the newspaper, you are basically buying that particular physical copy. You're
Yeah.
not buying that information. The information is actually copyrighted by the respective authors, or if there's a copyright transfer, then it's held by the particular paper. Uh, in that case, even if you hold a PDF, you are not actually holding, you are not the holder of the information. But it is freely available. Whether or not it can be shared is not specified. So if you have a physical copy, whether you can give it to somebody else, or if you have a PDF of that, whether you can specify freely shared is not specified. Ideally, it's not supposed to be done, because ultimately this is a, profit making business where the publishing house is selling and them. So ultimately, you are encroaching upon their profits. But ultimately, these are not clarified. If there's a particular publication which clarifies that there are books that are published under Creative Commons license, and these the physical copy of that book that could still be sold. That does not mean that you cannot sell the physical copy, but the text contained there is freely available. That's what freely available for sharing. That's what meant by the CC license. In case of newspaper, it's not freely available in most cases.
Okay. Thank you, Diptanshu. I think, Suhasini, you can start with the question answer session.
I'll do that, ma'am. Thank you so much. And thank you, Diptanshu. I think this is something we all need to be aware of, and you really made it quite simple and understandable. And so I'll now go on to the questions. Somebody has asked, I think, a tongue-in-cheek question, that are the pictures used in your presentation used with permission, and why have you not
Yes.
mentioned the sources?
Actually,
So we'll
the
start.
thing is, I'll be sharing the presentation. I'll be making it available for all, and actually put it in the notes portion of the slides. Ultimately, I did not get the time to put it systematically on the slides, which I'll eventually do. But unfortunately, I've not
Okay.
been able to do till now.
Sure.
Each of the slides has that information, so I'll be sharing that.
Okay. Somebody's been paying attention to the presentation. That's why he's asked this question, I think. It's anonymous, so we don't know who it is. So
It's
anyway,
good that
so
they are.
Yeah.
It's good that they are asking.
So somebody is asked with regard to plagiarism, what does excessive quoting mean with regard to plagiarism? Is there a term called excessive quoting, and is there any definition for it?
Yes, there are various criteria that have been set. For example, if we use more than 10% of the article, or there are other criteria, I have not specified it here because it's rather lengthy. Uh, if we do not go by those terms, ultimately we are making unauthorized use of it. So in that case, uh, that counts as plagiarism. So if I can cite directly quote something, it's not going to be more than 10% of the article.
Okay. So, okay, and Dr. Kavita asked a question. If you want to use a questionnaire from a previous study, but the author of that study is not responding to your mail, then how do you go about it? Can you
That
still
is
use
the
it? And
Yeah, that exactly is the purpose of the use of CC licensing. If you specify on your work that on my work, this is what I'm allowing and this is what I'm not, things become a lot easier. If you go in most of the cases, there are a lot of cases where a formal copyright transfer does not occur. So the author is the holder of the work. On the other hand, there are others where there is a copyright transfer and the publication house holds that information. Now, if the author himself or herself is not aware what exactly the case, because they have just signed the papers without even looking at them, because for publication they need to do what needs to be done. This is in most of the cases, and in that case it needs to be made sure whether you need to contact the publisher or you might be in a soup with this, and they might have a copyright resource center or they might not have. So a lot of gray area comes in with respect to copyright. Most often the authors, it's not that the authors are not willing not to share, but reaching them can be a problem. And in that case, if you make use of that, ultimately you don't have authorization for that.
okay. The next question is on Wikipedia. How do you, what is the accuracy and reliability of the information on Wikipedia? Because it is easily editable, like anybody can do what they want with it. So, how accurate is
Yeah,
it? How reliable is it? Is there an
uh,
external check on it?
yeah, I'll tell you. In case of Wikipedia, the accuracy has been seen to be at par with the Encyclopedia Britannica. In case of Wikipedia, there are various policies that are used to frame the contents there. So if I go and write something, there are a lot of people who are watching over the article. So if they feel that what I have written is inappropriate, they would be reverting in that. And if they think that I'm basically vandalizing the article, I might be blocked. So this is a process of vigilance that continuously goes on. And the more important a topic, the more visited the topic is, more are the watchers. So it's in such a case, any information that is not proper is very likely to be reverted very fast. On the other hand, if the article is very uh, less read one, there's very less prerogative to make bullshit edits to that article because nobody is reading it anyway. So in that case, uh, even there's less impetus and the uh, article is constantly being looked over. The next thing is Wikipedia needs you to cite the source, which needs to be a secondary source. So I'll have to if I make some edits to a medical article, I'll have to specify that I have got this information from this review article or this reliable source. In that case, ultimately, if I do not make that information available, and if somebody else does not think that this information is correct, it will be reverted very soon. So ultimately, in Wikipedia, bad information does not stay.
Okay. So somebody's asked, when we make our PowerPoint presentations, can we use images from various sites without attributing them if the sites are not mentioning any copyright issues? Do we
If
assume they are on whatever, like you said, they are on
no,
public forum?
by default, any work that we do is copyrighted. If I scribble something on a paper, I have not published it anywhere. I've just written it somewhere. That might not also be official. Ultimately, this information is copyrighted. So this cannot be used freely, and I cannot copy it as is. If it is informational, I can paraphrase it, provide it. For images, I need to obtain consent of the original photographer. For example, if uh, I am the photographer, I need to be contacted that uh, I need to make use of it. However, if you are making a fair use when you are using it for a restricted set of parameters, it can still be allowable. But in that case, you are obliged to cite the source that I have taken this from this source, mentioning the specific link and the author as applicable. So that is to be done. That is obligatory. Yes, I can make use of it in select cases only, but not by default. In my presentation, unfortunately for brevity of time, I could not make that information available. I'll be sharing that presentation with you all. Each of the information of the slides is available on the notes section.
There's a question that suppose we have an image or a video which does not identify the person, can it be used without permission?
Once again, there are two components involved. The person making the video, the person shooting the video is the owner of the video. So if somebody is making a video of mine, I myself am not the owner of the video, because it's ultimately the photographer who has the copyright. But at the same time, he needs to have consent from me that yes, I'm allowing that video to be recorded. In that case, here what is being talked about is the confidentiality issue and the privacy issue. In particular, privacy issue is there. If I give consent, you can use the video even without hiding my information. If on the other hand, if I say okay, you can make use of it, but I should not be identifiable, you need to respect that. In either of the cases, you need to get consent from the original author, who is the photographer here.
There's a comment that privacy is not only about a patient's body, it's everything about a person. I suppose that's okay.
Yes,
And two
absolutely.
congratulatory messages from Dr. Partha Ray that it was a brilliant presentation, and he's never heard on a medical forum such a comprehensive lecture, and all this authenticated information source that we should all be aware of. So compliments from him. And somebody's again asked, if we have not taken patient permission but the photographs are very old, can they still be used?
No,
Like maybe the child is an adult now and we think they probably will not remember.
no, there's a
They will
catch
not be
here.
recognized now. It's a 20-year-old photo
I
which
completely
is.
understand, but this is something like this is a old maybe journal or publication which is maybe 20 years old. this is like saying that can I copy from there, because that's old anyway, and maybe that's also not available on the internet, so people cannot locate it. So can I just copy the article in my name? The answer is no. But as I mentioned about the fair use and implied consent, uh, I'll say if that has real educational value, perhaps taking benefits of the gray zone, we can make use of it. Ideally, we should not. But here, that use should be for a very specific purpose, where it's for a benefit of education and things like that. When it comes to publishing it somewhere, we still need the consent on paper. So perhaps that would be difficult.
Okay. And now, if you're on the other side, suppose you find that your work has been copied without permission, then what legal recourse is available?
Legal recourse is available. In that case, the first step would be contacting the person and asking to cease and desist. That is, the first thing is asking the person that you are doing this. This is not unauthorized. Just stop using it. If the person complies, it's done. Problem solved. But if the person does not comply, or if you think that the person has gained significantly by use of this. For example, suppose you have made a commercial where you have used the image of Amitabh Bachchan, but it's just a image from anywhere. You have not taken the information consent either from the photographer or from the particular person, and the campaign that you have launched has significantly benefited you. Now, the copyright holder can sue you saying that you pay me this amount uh, because you have already made this much gains. A typical case in this regard can be uh, shortly back there was a song uh, Genda Fool by Badshah. That song had been copied from a Bengali poet, and the author had gained significantly from that particular video. In this case, the original author was rather naive. So ultimately, a lot of web netizens complained and created ruckus, for which Bacha paid only 5 lakhs to that person, which is just peanuts for him, and that person was satisfied. Case dismissed. In other cases, you might need to go to jail for 3 years if the person uh, complains and it goes that way. And there's a fine of I think up to 2 lakhs that might also need to be paid.
Okay, so just last couple of questions on plagiarism again. So is there a, can you plagiarize your own work? What is self-plagiarism? Is it possible to do
Yes.
that?
Yes, there are a lot of journals which prohibit self-plagiarism. Suppose I publish somewhere and I use directly the text from there into some other article. Ideally, this is not allowable. Uh, when a plagiarism check would be done using various applications, there are various paid applications and there are free ones. Free ones might have various limitations, whereas there are others which might not have access to what counts as deep web. Uh, in that form, I'm talking about paywalled journals. So suppose I am copying something from a paywalled journal. In that case, the free resources might not have access to that data, and in that case, the plagiarism check might give it clean. But in other cases, when I'm going for a proprietary software which checks has subscription to those journals, that is going to show up. So now, if I self plagiarize, ultimately that's still plagiarism, because ultimately that is going to show up. There's a limit that 10% of plagiarism report is acceptable, because there may be various portions which might be still closely paraphrased or ultimately similar. So sometimes there can be a 10% similarity, but that is not allowed even if you take the text.
So I think you answered the second question about the softwares as well. So I think we've had a wonderful session, which is very needed, but we don't really talk about it much. We're always talking about core neurology topics. It was very interesting. So thank you, Diptanshu, and thank you, ma'am, for chairing the session. And we wish you, thank you, ma'am, thank you, ma'am, thank you,
For asking
Diptanshu.
me to share. And just one thing, when
Yes,
it
ma'am.
comes to plagiarism, there is also some, suppose you're just using the definition, you're defining something for the readers, and the definition has to be picked up verbatim. So in that case, you must put it in inverted commas, and secondly, you state the source very clearly.
Yes,
Is that
yes, ma'am.
Anshu?
So I think
Uh,
that's what we all
Hello.
need to be very careful about now. Yeah. You want to add something, Diptanshu?
No, I was getting some voices. That's it.
Okay, then. I think that is
Yeah.
also fine.
So I think we will wind up. A very good night to all of you. And thanks again, Diptanshu, and thank you, ma'am, for this
Thank
wonderful
you.
session.
Good
Yeah.
night.
Bye bye.